Welcome to everyone. My name is Dan Greenberg. I'm General Counsel at the Competitive Enterprise Institute, and I'm also co-counsel for Charles and Kathleen Moore. The reason I say that is that yesterday, we formally asked the Supreme Court of the United States to hear the case of Moore versus the United States. The technical way of saying that is that we filed a petition of certiorari. The Moore case has the potential to be the most important tax case of the 21st century, and we've assembled a panel of experts today to discuss the many issues that the Moore case raises. We have Andrew Grossman of Baker and Hostetler. He's CEI's favorite outside counsel. He's one of the leaders of Baker and Hostetler's appellate and major motions team, and he's appeared at just about every federal appeals court in the nation. And he is chief counsel and attorney of record for the Moores in Moore versus United States. Professor Hank Adler is also with us. Professor Adler has taught accounting at Chapman University for, I think, 2 decades. And before that, he was a tax partner at Deloitte & Touche. And one reason we wanted him on our panel today was his recent op-ed on the Moore case in the Wall Street Journal. And I think it contained a concise and powerful explanation of the Moore case's legal and political significance. We also have Devin Watkins, who is my favorite in-house counsel at CEI. He previously worked at the Cato Institute and the Institute for Justice, and he's a kind of utility infielder for CEI who covers the entire playing field of law. And in a moment, I'm going to ask Devin to tell us a little bit about the Moores and how they became involved in this case. Before I do that, though, I'd like to say something about the most important person in this entire proceeding. And that person is you, the viewer, because we have a mechanism set up to take your questions. Over the course of the next hour, I'll be asking Devin and Hank and Andrew a lot of questions, but if you have any questions for us, I invite you to join our discussion. There are 2 ways that you can ask our experts questions. You can use the Q&A button at the bottom of your screen, or you can send an email to events@cei.org. If you do that, do either one of those 2 things, it'll shoot those questions over to me immediately. I'll ask them for you. I probably won't be able to ask your questions immediately, but I will get to as many of them as I can. Now, having said that, Devin, can you tell us a little bit about the Moores? Why are the Moores involved in this case? What is the circumstance that they encountered that caused them to take issue with the federal government?
Sure. Let me give you a little background. So Charles Moore was a software developer at Microsoft. And while there, he became friends with his coworker, Ravi. Ravi took regular trips to India, and while in India, he noticed that there was a lot of small family farmers who used simple hand tools rather than the powered farm tools that are readily available here in the United States. So he had an idea. He decided he wanted to create a new business called Craft that would offer powered farm equipment to these small farmers in India and make them far more productive at producing food. But Ravi needed money to get his business off the ground. So he asked Charles Moore, his friend, and his wife, Kathleen Moore, to invest in his company. This is a lot of money for the Moores, and they asked Ravi how they would be paid back. Ravi thought the best way for the business to succeed would be for the profits of the business to be reinvested in the company. So the Moores would only see a return on their investment if or when the company was sold or had an IPO. That presented a lot of risks to the Moores because they wouldn't see a return on their investment for a long time. And if the company went bankrupt before it could be sold or IPO'd, they might never see a return on their investment. Still, the Moores believed in the mission of Craft in helping these disadvantaged family farmers. And for that reason, they were willing to take the risk. They invested $40,000. And to this day, they have not seen a single penny of return on that investment.
But Devin, what did the Moores receive in exchange for that investment? Particularly, what kind of document did they receive and what kind of tax obligations did they get?
So they received a tax bill from the IRS as a part of the Mandatory Repatriation Tax that was enacted in 2017. They had been passive investors. They were minority investors, but really not doing much with it. It was Ravi who was operating the business and running everything. But then they one day surprisingly got a tax bill from the IRS.
So they received a tax bill from the IRS, more precisely, an income tax bill from the IRS. Devin, can you explain in round numbers how much income they got from this that created this income tax obligation?
They got nothing from Craft. They invested $40,000 and they have not seen one penny back from the company.
So if I may, Andrew, I'd like you to talk a little bit about the nature and the limitations of the federal taxing power. A friend of mine in law school once said that she came to understand law school completely when she thought of practicing law as basically understanding a series of recipes. If you want a recipe for cornflakes, right, then you got to get the bowl, you got to get a spoon, you got to put the cornflakes, you got to put the milk in the bowl. So what's the recipe? What are the constitutional and legal limits of the federal taxing power? And I know that it has changed over time. So if it's all right, let me ask you to talk a little bit about what the nature of the taxing power was before the 16th Amendment and the nature of the taxing power was after the 16th Amendment.
Sure, Dan, and thank you. I think that's exactly the right way to break it up. When the framers were putting together the Constitution, they recognized that one of the chief problems under the Articles of Confederation was that the national government didn't have a taxing power. It had to rely on requisitions from the states, and it was really an untenable thing, and it really prevented the federal government from carrying out uniquely federal functions. So they were determined to give the federal government the power to lay taxes, but they were also concerned, remember the concerns that led to the revolution, that if you had that sort of national power, it could be abused, it could be applied in oppressive ways, it could be applied in ways that were unfair, that would, where a group of states in Congress might gang up against another state and impose oppressive taxes on that state to pay for all of these national programs. And so they came up with what at the time was a pretty sensible and well understood divide. They recognized that there were two types of taxes generally: direct taxes and indirect taxes. Indirect taxes are things like tariffs, excise taxes, that kind of thing, use taxes. And the rule for those was that they had to be uniform. But then for direct taxes, they chose a different path. So direct taxes are generally things like capitations, taxes on land and other property, and ultimately things like income taxes in many instances. And so the problem with direct taxes is that they were simply too powerful a tool. They could be used, by a group of states to gang up against other states. And their view was the federal government ought to have the power to impose direct taxes, but it really ought to be something that would just be a last resort, things that might be necessary in times of emergency, war, etc. And so the rule they laid down was a complicated one. It was one of apportionment by population. What that means is that when Congress, under the original Constitution, laid a direct tax, it had to be divided up in amount based on the population of each single state and then imposed in that manner. So, for example, if there's a head tax, in other words, a tax on every single person, that naturally is divided up by the states on the basis of population. But if you have something like a tax on property, well, that also would have to be divided up in that manner, and that's a very difficult thing to do. But again, making it difficult was the point.
Right, and so it's fair to say that a direct tax that Congress passed before the 16th Amendment, it's not impossible, but it's something like very difficult or practically impossible with respect to a variety of taxes we can think of, right? It's just administratively very difficult to create direct taxes up until the era of the 16th Amendment, right? And so that's why there was a reliance on indirect taxes up until the era of the 16th Amendment. Would you agree with that as a very general matter?
As a general matter, and there were a few direct taxes, and they were generally apportioned. And so in many cases, the collections were actually undertaken by the states and their revenue collectors rather than the federal government itself. That's how we paid for wars and things like that. But again, very unusual circumstances.
And then we come to the era of the 16th Amendment, in which one might say the floodgates of taxation were opened, right? Because the 16th Amendment is a little different in that it provided this entirely new, relatively less regulated power for the federal government. Is that fair to say?
Well, I don't think that's quite right. I think you need, a small measure of history to understand, what the 16th Amendment is and why it's structured exactly the way that it is.
Mhm.
So Congress did ultimately impose a fairly broad income tax in the 1890s. And ultimately, the Supreme Court struck that down because it included taxes on the income from land and from personal property. In the court's view, those were direct taxes as that term was originally understood. And so after that, you enter into the progressive era. And there was a real push to expand the federal government as well as to do some redistribution of wealth. And really, the only way to go about that was something like an income tax. There was talk in Congress about enacting another income tax and taking another run at the Supreme Court, but cooler heads prevailed. And the approach that they settled on was not to repeal the apportionment requirement that was considered, it was rejected, but to do something that was significant but much narrower than that. What they did was, in the 16th Amendment, was to authorize Congress to lay and collect taxes on incomes from whatever source derived, but without apportionment among the states. So solely for taxes on income, Congress could lay a direct tax, but wouldn't have to apportion it.
Very helpful. So Hank, I want to ask you a question, which when I first heard this question, I thought the answer was simple and obvious. But now that I've spent too much time in law school or grad school, I think it's not really an obvious question. Hank, my question to you is, what is income? How do we tell whether something's income or not? How at a very general level, how historically have courts and bureaucratic actors understood when income takes place and the corresponding tax obligations that it develops? What is income?
Well, historically, with respect to income in our country, there needed to be a transaction. There needed to be an event. A handful of court cases going back to really 1913 that have said something has to happen. We have to have a transaction so that we can measure the income.
Yes, and so I think of it this way. I think part of understanding that question is, you look at the common understanding of the word, and it has something to do with the idea that something is coming in, right? That has something to do with income.
Yeah.
So Devin, let me get back to you because it looks as if in 2017 something happened, and we have this slightly different type of tax rule and it's unclear exactly whether it taxes income or not. Devin, tell us a little bit about what the mandatory repatriation tax is.
So in 2017, as you were saying, Congress wanted to bring money that was overseas back to the United States. This money would have been taxed if it was brought back to the United States under the prior taxing regime, but they wanted it to be brought back without taxes, or at least with reduced taxes. But Congress needed to figure out some way to pay for it. And to pay for it, they decided to go with a mandatory repatriation tax. As I was saying, historically, when that money was brought back to the United States, people would be taxed on that when it's brought in the United States. That was called repatriation of the money, and you'd be taxed on that. But this new tax, called the mandatory repatriation tax, just deems this money that's still overseas in the hands of the corporation to be the income of the shareholders. This tax in particular is triggered if the shareholder owns shares of that company on November 2nd of 2017, on that day. If you own it before or after that day, it doesn't matter. It's only on that day the owners of the corporations are taxed. And it's because it's taxing them on triggering on if they own shares in the corporation. That is, in my opinion, what causes it to be a direct tax. The amount of that tax is based on the undistributed profits of the company after 1986 and based on the percentage that the shareholder owned of the corporation. But it doesn't require the shareholder to have received this money. It just deems the money to be their income.
So to be clear, what creates tax obligations, and more precisely, what creates income tax obligations under the mandatory repatriation tax, is the ownership of something on some particular date, November 2,
Yeah.
2017. That is what triggers the activation, right, of the mandatory repatriation tax. Is that right?
Yes, that is kind of the triggering event that that causes this tax to be owed.
So the larger question here, to my mind, is the mandatory repatriation tax an income tax? And I think that's kind of an issue that is what is at issue, or certainly one of the things that's at issue in the case, in the controversy, you might say, between the Moores and the Internal Revenue Service. Andrew, maybe you could tell us a little bit about what happened to the Moores, and particularly what the judgment of the district court and the appellate court in the Ninth Circuit was when it analyzed the question of the obligation of the Moores to pay this tax and why they were obligated.
Sure. So the Moores went to court, and their main claim was that this tax, the MRT, is simply, it's not an income tax that's authorized by the 16th Amendment. It is instead a tax on property, their shares, and it's not apportioned, and for that reason, it is unconstitutional. We brought that claim in the district court. The district court recognized that Supreme Court precedent dating back to 1920, a case called Eisner versus Macomber, held that there was a requirement for income that it be realized. In other words, there are different ways you could discuss that, but it's sort of the idea that you receive the money, it comes in, you lay your hands on it, you have some control over it, something of that nature. In other words, when you get the economic gain in such a way that you can actually make use of it. In a general sense, that's income. The district court recognized that that's what the precedents held, but in the district court's view, those were old precedents, and some lower court decisions had maybe seemed to go the other way. And so really, without further analysis, the district court declared, well, close enough, this is an income tax. The Moores then appealed to the Ninth Circuit, pressing exactly the same argument. And the Ninth Circuit really went a step farther. In the Ninth Circuit's view, there's no requirement whatsoever that anybody realize anything. If Congress simply deems something to be income, then it is income and Congress can tax it. So under the Ninth Circuit's view, Congress could deem your property to be your income. It could deem you to have a pile of money that's lying over there. That could be your income. Congress can just deem something to be money. It doesn't matter whether you've received it or have control over it or anything like that. And then having deemed it to be income, Congress can then go ahead and tax it. Based on that view of the law, the Ninth Circuit went ahead and ruled that there's simply no constitutional barrier to assigning to a shareholder, any shareholder, a proportional share of the corporation's retained earnings and then taxing them on this. And I want to make clear, this retained earnings thing, there's nothing unusual about it. Every corporation in the world, the way it grows is they earn money and then they reinvest the money in the business. So it's not like there's a pot of money sitting out there and somebody has set up some sort of artificial corporate form or something like that to avoid taxation. This is what businesses use to grow. It's not necessarily available for distribution to the shareholders. And when you're talking about minority shareholders like the Moores, they're like any shareholders in the country, right? Everybody who has shares in their 401k or owns mutual funds or anything like that, all those companies that they own shares in, they all have retained earnings. And in the Ninth Circuit's view, Congress could simply declare all of those retained earnings, hundreds of billions, trillions of dollars, to be the shareholders' own income, and then go ahead and tax them on it. So it really was a very far-reaching and somewhat disruptive ruling.
So I want to ask you to expand on that, because I'm sort of interested in the way courts do business, and I want to ask you a few doctrinal questions about that to make sure that I understand what you're getting at. Say a little bit more about whether it's a controversial move to say that Congress can define the meaning of certain terms, especially if it's the case that there's doctrine from the Supreme Court on record, which seems to have covered the territory in terms of explaining what the meaning of certain provisions is. I mean, at that point, Congress has a limited amount of discretion to explain the meaning of certain terms if it's true that Supreme Court doctrine has already expanded on their meaning. Is that fair to say?
Yeah, I mean, in a general sense, as Justice Kagan said, we're all textualists now.
Right.
And indeed, the whole point of a written constitution is that those words do in fact restrain the organs of government and thereby protect liberty. So it really is incumbent generally upon the courts to ascertain original meaning and where appropriate to apply that, sometimes in opposition to the other branches of government. In a more specific sense, that's what the Supreme Court in particular had always done with respect to the term income. Ever since Macomber, and indeed there are decisions that go well before Macomber that involved that term, but ever since Macomber, the court had recognized that income refers to the realization of some type of economic gain. In other words, it's not enough that the value of your property might increase or something like that. For example, your house might go up in value. You have to get the money for it, and that's what triggers income and thereby a potential tax obligation. And so it was a very strange thing for the Ninth Circuit to take those precedents and say, well, yeah, they said that, but they didn't really mean that. The way the Ninth Circuit explained it is that those seminal cases by the Supreme Court didn't themselves declare that they were setting forth a universal rule, which is sort of an unusual way to try to avoid Supreme Court precedent, because it's a very rare thing that the Supreme Court stamps on an opinion, we really mean it, this applies in every case.
Right.
Instead, the court simply interprets the Constitution. So the Ninth Circuit's key doctrinal move here was really a bit unusual.
Well, I want to ask you a related question, quite related to what you're getting at, which is the doctrine of silently overruling precedents. The notion that we can say, for instance, well, I recognize that these are precedents here, but they're old precedents and they've been silently overruled. Now this to me is a puzzling type of argument for a court to make. If we can't find evidence that a doctrine has been overruled and we say, well, it's been silently overruled, this strikes me as a general matter, something of a controversial move, because it seems like, again, it gives a lot of discretion to lower courts to ignore precedent that's on the books. Would you agree with that as a general matter, Andrew?
Well, I don't think it's controversial. I think it's just wrong.
Yeah.
The Supreme Court, the Supreme Court has said time and time again that it retains the prerogative to reconsider and overrule its own decisions, and that the lower courts should not attempt to predict that the Supreme Court might do such a thing or take the matter into their own hands. So in that respect, I look at it and I think that the Ninth Circuit misread those cases, but it really did give short shrift to the Supreme Court's very consistent precedents in this area. And I think that's something that has really serious consequences.
Yeah, so I agree with all that. And I will just add, there's a general rule that lawyers are always supposed to be appropriately respectful of courts, and that's why I occasionally resort to euphemism when I say, well, this is a puzzling move or this is an unusual move by a certain court. And I appreciate, Andrew, your more direct way of characterizing the very unusual moves of the Ninth Circuit. So I guess I would now ask one more question for you, Andrew. Say a little bit about the doctrine or the opinion that was set forth by the 4 dissenting judges on the Ninth Circuit. Can you say a little bit about the way they illuminated what might be understood as a misstep by the majority of judges on the Ninth Circuit?
Sure. So the Moores, that is, filed for rehearing en banc, that is, to ask the full court, or at least a larger panel of the Ninth Circuit, to reconsider the case. And the court denied that, but there was a dissent by Judge Bumate, joined by 3 of his colleagues. Judge Bumate's dissent looks at it, I think, from the way that the Supreme Court traditionally looks at these types of questions, based first on precedent, then on original meaning, and then thinking about the history and tradition in this area. So far as precedent, Judge Bumate's view is that the panel opinion simply botched its understanding of the applicable precedents in this area, particularly Macomber, but also a series of cases that have come after that have all recognized that income requires realization. In terms of original meaning, the opinion, Judge Bumate went on to explain, income means income, it's coming in, but also the text of the 16th Amendment, which refers to incomes from whatever source derived, reflects that income is going to be derived from a source. It's not merely a gain, or it's not merely deeming something one way or the other, but it's something coming in, it's something being received, in other words, being realized. And there's also a structural issue, as Judge Bumate pointed out, that Congress declined to simply get rid of when Congress was drafting what became the 16th Amendment, Congress declined to simply get rid of the direct tax clauses. Instead, it took a much more specific and narrow approach of not requiring apportionment only for taxes on income. But if Congress can simply deem something to be income, then as Judge Bumate explains, well, what's left of the direct tax clauses? I mean, how could anything ever be subject to the apportionment requirement if Congress can just get around that in every instance by deeming something to be income? And finally, he looked at history and tradition in this area, recognizing everybody knew what the term income meant. And there's been this consistent historical understanding extending from well before the 16th Amendment down to the present day. This isn't sort of a mysterious word. It's something that we all use colloquially, and it's used in a legal sense in exactly the same fashion. So in his view, not only was the court wrong, but it was wrong in a very radical and serious and dangerous way. It was the first court ever to hold that Congress could tax something as income that never has been commonly understood as income. It was, in effect, a through the back door property tax, and that would have very serious constitutional consequences, including allowing Congress to tax things like property as well as wealth, if that decision were to be taken seriously.
So I have a couple more questions for you, but I also have a few questions from our listeners, and some of them have to do with this question of what is income. Right. And I want to get back to you for a second, Hank, and I want to ask you, if I could, a question or two along the lines of what is income? Is this particular thing I'm going to talk about, does this fall inside the income box or outside the income box? And here's my first question for you, Hank. I have some knowledge of the way income works on a debt, in that if I were to lend someone money and say, you need to pay all of this money back and all the interest back in one payment 10 years from now, I think that I'm going to have tax obligations. I'm going to have income tax obligations as the lender, not just at the end of that 10-year period. I think I'm going to have income tax obligations every year, right? It's not all just one income tax obligation at the end of that 10-year period. I think that that's right. That's what's called imputed interest, right? That I have to start paying off the income from the value I hypothetically receive.
Well,
Does that sound right, Hank?
Yeah, you're close. We have in accounting the concept of an accrual basis taxpayer who is going to recognize their income upon the agreed amount over that period of time. Here we're dealing with a cash basis taxpayer who had no transaction. And, I kind of think about this in a much more human being basis. Look at the appreciation in FTX if you were a shareholder, and the thought process that on a specific date, somebody would say there was income because the value of the stock had gone up. And now look 3 months out and you see it's worthless. There was no transaction. There's no way to pay the tax. I think it's a good simile to trying to understand why income requires this realization event.
Right. And so the reason I asked you that relatively simple question is because we got another more complex question from a listener, and he again wants to know essentially what is income, and he asks, I can think of some examples of some individuals who who face unrealized income, such as Section 1256, mark-to-market, unrealized gains and losses on futures contracts. That's in, so section, is Section 1256 unconstitutional? Does it pose problems for a theory of income, or is Section 1256 income conventionally taxed and taxable and understood as an income tax obligation?
It's a perfect question. And the reason this is such an important case is sections like 1256 could very much come into play and could very much be considered unconstitutional.
So
it's a brilliant question.
yes. So in other words, there are some large implications, right? That could be triggered by a Supreme Court decision on this question, because it creates the possibility of clarifying what is a slightly indistinct doctrine, which is to say, what is income, right? And
yeah, you're exactly correct. I mean, one of the things we've chatted about is what are the ramifications for future legislation should the court take this and find that realization is no longer a requirement. Could we have a wealth tax? On the other side, the gentleman who asked the question is 100% correct. There are some sections that would take a relook, and possibly the guilty laws with respect to what replaced the CFC rules.
But I would also say, and I hope you'd agree with
so
that,
Dan, if I could.
Yes.
I apologize. You know, I'm not sure I see it exactly the same way that Professor Adler does, at least for the mark-to-market and some of these other things. There's this concept in tax law called constructive realization.
Yes.
You know, with the idea that, you know, with the idea that somebody, even though they might not literally have the money in their hands, they have control over it. They have some type, there's some type of transaction, there's some type of result that is sufficiently close to realization that the law has regarded that as realization. And there are some Supreme Court cases and a lot of lower court cases that uphold that principle. And so with something like mark-to-market, if you're dealing with contracts that are settled on a daily basis, where the money effectively is in somebody's account on a daily basis, there may be some discretion for Congress there to say, you know, that really looks like realization. And if it isn't realization, it's effectively constructive realization. And, you know, when you talk about all these different provisions of the tax code, a lot of them work on that basis and have been defended and upheld on that basis. What makes this case different than all of those is that everybody agrees that the Moores did not realize anything, not actively, not actually, not constructively. So that's really what makes this case different, but as well as very interesting and significant, because, you know, unlike all of those other taxes, there is no claim of realization here. And so there really is just that bare constitutional question, do you need realization or not? And if the answer to that is no, then it's open season for things like a tax on property at the federal level or a tax on wealth and so forth. And so really this case and this tax are a little bit different, I think, than the ones that have come before it and have been subject to some judicial challenges.
Yeah, I actually agree with you on that, Andrew. And I wonder if I could ask you one other question about that, which is, it seems to me that most of the time when we're trying to figure out whether something is income, it is really quite clear whether something's income or not. And there are a few cases where it's perhaps just a little bit indistinct or ambiguous as to whether something is income based on past case law and the text of statutes. But in our case, the Moore case, it seems like there's a pretty strong argument that it's not indistinct at all, right? I mean, our view is that we're not facing an indistinct question or an ambiguous question. Our view is that there's a bright constitutional line, right, that takes all the indistinctness out of it, and that there's a pretty clear answer based on time-tested, not overruled cases that dictate the answer that this just doesn't fall into the realm of income at all. Would you agree with that, Andrew?
You know, I would. I mean, in every other case, there's this question, was there realization or not?
Mhm.
And you get into these really complex, hairy arguments because many times Congress enacts these tax code provisions that are meant to prevent tax avoidance. And so they have to operate in circumstances where there may be some ambiguity or lack of clarity. And so you're always going to have that type of statutory question and question as to whether or not there was realization. But here, it really is just a pure legal question. It's undisputed that there was no realization. And so the question is, okay, this money that the Moores were deemed to receive, is that, as a matter of law, is that income or not for purposes of the 16th Amendment?
Thank you. So Andrew, I do want to ask you one other question. It's a relatively easy question, I think, but I mean, I think it deserves some emphasis. One sort of remarkable thing is that it seems to me that there's a strong case that the Ninth Circuit is in this decision. It's doing things. It's entering territory that's kind of unexplored territory. And when you especially when you compare that to the case law and the holdings of other circuits, such as the First Circuit and the Fourth Circuit, indeed, there's an argument that it's unexplored territory when compared to past Supreme Court findings. I wonder if you could say a little bit, especially for our non-lawyers, about what is a circuit split, and why are circuit splits attractive to the United States Supreme Court, and why is that relevant here when what the court has on its hands is a petition to hear the case?
Sure. So a circuit split is simply when two of the courts of appeals, or perhaps more, have decided a question of law in conflicting ways. In other words, so that different law applies in different parts of the country based on where a case occurs. In this instance, yeah, the Ninth Circuit did break with the views of the Fourth Circuit and the First Circuit, and arguably several others. But those lower courts were simply following the law as laid down by the Supreme Court, at least as they understood it, and as the Supreme Court did appear to enunciate it. But it has created this circumstance where in the Ninth Circuit, potentially, a tax on all shareholders or a tax on wealth or something like that would pass constitutional muster, whereas in other circuits in the country, it most likely would not. That's something where the Supreme Court often hears cases, where there is this type of conflict. But the court also hears cases where lower courts have simply flouted governing Supreme Court precedent. And certainly that's what the Moores have argued as well occurred in this instance.
So I wonder, Hank, if you would like to peer into your crystal ball and talk about the political consequences of this case. If you'd like to say a little bit about the consequences of a decision finding in favor of the Moores, that in fact, this tax obligation that's been created by the IRS has nothing to do with income tax, and as a constitutional matter, it's not kosher for the Moores to face an income tax obligation here.
Well, I think I have to look at the future more than the past. I think it stops, hopefully instantly, wealth taxes and some redefinitions of words that we thought we knew the meaning of. I think probably the classic and state court, obviously different than federal law, different constitution, et cetera. But I think the best example now is the state of Washington has redefined a capital gain as an excise tax. And suddenly we face a world where words that we thought we knew the meaning of no longer have that meaning according to legislatures. So I think that if the Moores succeed, a lot of these reinterpretations around the country will cease. At least I hope so.
And let me ask, think about like the photographic negative of your answer. What are the consequences of a decision that finds in favor of the government, that says that this is a perfectly appropriate use of the income tax? Hank, you want to talk a little bit about that?
Yeah, I think it's a classic slippery slope.
Yeah.
I think at that point, we could be looking at wealth taxes specifically. We could be looking at appreciation of assets specifically. I draw some distinction between the two, but Andrew will tell us, and I think he's correct, that both of those are wealth taxes. And I just think we see a potpourri of new taxes over, whatever period of time we're looking forward to.
Hank, I do want to ask you about an entirely different matter that I know that you're interested in. Can you talk a little bit about I guess what I call the look back provisions of this tax? I mean, I know that in the past it's been found constitutionally appropriate for courts. I mean, courts have, you might say, blessed taxes that create tax obligations for one previous year, or in the past 18 months in the past. I guess this case sort of it has the potential to create new rules, right? Because the look back period actually creates taxable events that are 2 or 3 or 4 decades in the past, right? So I mean, it could sort of rewrite in some sense people's tax obligations from decades ago. Is that a new thing, Hank, or is that a new kind of tax measure? Does that sort of rule that looks back at people's behavior 10 and 20 years ago and retroactively changes their tax obligations?
Yeah,
How much background do we have in this in the enforcement of the tax code in this sort of matter?
I will carefully choose the word frightening for this. As
Uh-huh.
you know, this is a key point to me. The Carlton case, which I think is the key case on this look back, as you just said, 1.5 years. But if you think about the Moores losing and no one taking a second look at the Carlton case for how far you should go back, and there's a great dissent by Scalia on this. In theory, we could have a law that said you are not taxable on the undistributed earnings of a stock that you bought 40 years ago for the intervening 40 years. I don't think there's much difference intellectually if we throw out the concept of, really, I'll use inappropriately the term statute of limitations. It gives the government back the opportunity to go back as far as they wish. And I'm hopeful that the court will address that issue as well.
So very generally, and I'm just, maybe you can help me remember this, Devin, because I'm not sure I know. How far back does the Mandatory Repatriation Act go in terms of looking at income, in terms of looking at corporate income that drives the size of the tax obligation? I mean, it goes back something like 30 or 40 years in some cases, doesn't it?
Yes, it goes back to post 1986 income.
Mhm.
So say there was a long time ago in 1987, and they won the lottery. The business won the lottery, got an enormous amount of profits from this, and then just didn't have any profits or losses for 30 years. Even today, the people could be taxed on that lottery winnings back then. It's kind of strange, but that's the way this tax kind of works.
And perhaps any of the panelists would like to comment on, I mean, I know that we don't like this. I know that to us it seems unfair. Is there possibly a constitutional argument? Is there possibly some piece of the Constitution or some phrase in the Constitution or one of the amendments that we think of when we think, gee, this seems unfair with respect to barriers to retroactive taxation, such as, say, the Due Process Clause?
Yes, we had raised the Due Process Clause in the District Court and the Ninth Circuit, which we still feel the Due Process Clause should prevent this kind of retroactive taxation. But it's not in our petition to the Supreme Court, which is focused exclusively on the direct tax argument.
But as I understand, the Supreme Court has the opportunity to look at any and all issues that they consider relevant to the case, and they have the opportunity. And I'm certain that some of the amicus curiae briefs are going to address this issue of retroactivity.
Yes, if they decide they want to look into this, they could. I know in another case, we have asked the Supreme Court to add a question to a cert petition, but it would be up to the court to make that call on their own.
So I think that we have a very interesting question from one of our listeners, asking, have other plaintiffs brought cases challenging the MRT, especially large institutional investors? If not, why not? Well, I think that there are a couple of interesting answers to that, and I wonder who would like to address this question. I invite any of you to explain the silence, the relative silence of litigation on this question.
Let
Well,
me jump. Go ahead, Andrew.
I was just going to say, when you have large corporations, oftentimes it takes many years for them to resolve their tax disputes with the IRS, at least to a point where they might be able to go to court because there is an administrative exhaustion requirement. So it is still probably premature to see many challenges. I would also, as a practical matter, many corporations that have complex tax affairs often do negotiate with the IRS. They reach deals, they reach compromises, and so that's a reason why you may not see cases involving those types of plaintiffs also quickly or necessarily at all.
Well, I think that's exactly right. And if I'm remembering correctly, there might be an additional reason in that I think that the MRT treats institutional investors and individuals a little bit differently in that there are sort of corresponding deductions for corresponding is the wrong word, in that there's some level of deductions for institutional investors in a different part of the bill that arguably makes their burden a little bit smaller than individual taxpayers. And this is just a kind of unique historical circumstance that we have any kind of, that we really have any individual taxpayers facing this kind of burden at all. It's just sort of statistically unusual. And so I am inclined to think that this particular case, almost by accident, sort of forces the consideration of certain constitutional questions. Hank, did you have something to add to that?
Yeah, I do. I do want to add to that. My colleague Lacey and Willis and I wrote on this, God, now 5 years ago. And in our first paragraph, we said that the tax rates chosen, these low tax rates, had more the act of a settlement agreement because the tax rates were so low. And that getting this money back at those low rates was probably seen by most corporations as the best deal on the planet. That they weren't faced with taxation on the dividends at traditional rates.
So I want to say something to our panelists, and I want to say something to our audience. First, to our audience, we are about to run out of time. So if you have additional questions, we're getting close to the hour. So if you have any more questions, submit them now. To our panelists, I wonder if any of you feel that there's some facet or some dimension of this issue that you have not been able to address yet, and I would be delighted to hear any one of the three of you speak on anything that we have not covered in sufficient detail as of yet.
I'd be happy to talk about some of the differences between some of the types of corporations that fall within this.
Right. Yeah. I do want to ask you, Devin. Yeah. Say a little something about when partnerships receive income, Devin. When partnerships receive income, is that subject to the same sort of objections that the Moores are arguing? I mean, because people in partnerships are facing a slightly different position than the Moores do when income comes into that partnership. Talk a little bit about that.
Yeah, so with a partnership or an S corp, there isn't, for tax purposes, there isn't a legal separation between the entity and the owners. The profits of the company in an S corp are the income of the individual. They are kind of, in some ways, the same entity for tax purposes. In similar ways for a partnership, where you have all of the partners The partnership's profits are the profits of the individual members of the partnership, while a C Corp is a legally kind of separate entity for tax purposes. It has its own tax rate for the income that's coming in. And this is what makes it slightly different for constitutional purposes, so that the income and money that are coming in to a C Corp are legally separate entities than the owners that own that C Corp. The income of the company is not the income of the shareholders, but it's different somewhat so for a partnership. The income to the partnership is the income to the partners. And it has to do with the way partnerships are treated. Partnerships are very, very old in the way that they are handled long before the formation of these kind of modern corporations.
Thank you. Andrew, I would just invite you to explain the same thing that you explained in your petition to the Supreme Court. Can you tell us, why should the Supreme Court take this case? The Supreme Court takes 1 out of 100 cases that it's presented. Why should this case be that 1%, be a member of that 1% of the cases the Supreme Court hears?
Well, Dan, that's a great question, but rather than me give my views on that, I'd be really interested to hear what Professor Adler has to say about this sort of the significance, the issues in play, his sort of top level view of these things.
So kind of you. I believe that this really is the opportunity to provide the greater community with a confirmation of what the law has been. What confirmation of essentially what you write in your brief is that, are we requiring a transaction, a realization? And I believe that that is just crucially important in the political sense of everything we read in the paper every day. That, is Congress allowed to have a wealth tax, to impose a wealth tax? Can they do any other sort of things? Is Congress in a position like the kings of years and years ago, where they can just come down and collect money based on our wealth on whim? So I think it's just crucial to having a tax system that everybody understands and knows what the rules are. I just don't think it could be more important. Or I've been writing on it for 5 years, and that's the reason.
Well, I want to thank all three of you for explaining how this works. I want to thank all three of you for explaining what I think has the potential to be the most important tax case of the 21st century.